Application is Liam Campbell against the Republic of Lithuania.
Yes.
My Lord, I appear with my learned friend Mr. Sean Devine for the applicant in this matter, and my learned friend Mr. Gerald Simpson, Queen's Counsel, and my learned friend Mr. Stephen Ritchie appear for the respondent in this matter. My Lord, we've prepared a short note just summarising the history of these proceedings and the summary of our response.
Yes.
But in essence, my Lords, the point that arises is that there's nothing in either the framework decision or the Extradition Act to address the problem of a defendant who is engaged in the process in one jurisdiction and then gets arrested in another. There was no evidence in this case, and indeed there was a judicial finding that he had not absconded in crossing the border. And our essential submission is that the prior executing state, within the test and the framework decision, the prior executing state should take priority, unless, of course, you have absconded into another state. But just to summarise the history, your Lordships have in the short note, which really draws on the High Court judgment, that an EAW was issued on the 18th of December 2008 by Lithuania, and your Lordships have that in the High Court judgment, which I hope you have.
Yes, I mean, we've seen it.
Yes. Well, my Lord, that's the essence. Perhaps I should just draw attention to certain matters.
Yes.
Roman 3. We submit that his case...
This is Roman 3 of which of your
1.
very
1.
many documents, Mr. Fitzgerald?
My Lord,
Note for leave hearing.
the note for the leave hearing, my Lord.
I see, that's one of the two new, there's nothing to do with supplemental submissions, that's
Yes.
the note. Okay, yes.
Yes. Roman 3, my Lord. So the applicant was arrested pursuant to the Republic endorsed in the... the warrant endorsed in the Republic. Ireland then became the executing state, and his case was joined to that of two others facing extradition to Lithuania from the Republic. The alleged offences were of conspiracy to acquire firearms and explosive devices and the transportation of them to the Republic of Ireland without permission. And then, your Lordships will see, he was granted bail by Mr. Justice Peart on the 26th of January 2009. It's relevant that he's a citizen of the Republic and lives in the Republic. There were then a series of hearings in the Republic. He remained on bail. Expert evidence was obtained, and his points of objection were due to be filed by the 17th of June 2009. And then, of course, the arrest intervened and the commencement of the proceedings in Northern Ireland. But just to finish the history in the Republic, subsequently proceedings against the applicant in the Republic were discontinued because the Republic of Lithuania withdrew its extradition request in the Dublin High Court.
So what happens if he wins?
Then they could reinstitute the proceedings in the Republic without any difficulty. I mean,
When did they discontinue them?
my Lord, I think it was during July of 2009. Yes. So during the course
July?
of yes, July 2009.
I see, I don't believe we've ever been told that before.
Well, my Lord, it's set out in the paragraph 48 of the judgment. Your Lordships will see. Yes, in the High
Judge
Court.
Burgess's judgment?
No, it's in the judgment of, because it hadn't happened at the time of his judgment. It's at paragraph 48 of the High Court judgment.
I see.
We consider that, if I could just take your Lordship to that, we consider that there is an increasing emphasis in public law on substance, which may differ from those prevailing. The present case is a paradigm example in this respect. We consider it would be wrong for this court to overlook the fact that within 2 weeks of the reported ruling, the Republic withdrew its extradition request. It seems to us that the effect of this development was to extinguish the cornerstone of the abuse argument. And this is the unequivocal acknowledgement on behalf of the applicant. There's no challenge to the validity of the EAW.
Well, why does it make any difference which of these jurisdictions determines this issue?
Well, my Lord, we say as a matter of, because
why in substance does it make any difference?
Yes, because he's a citizen of the Republic. He was arrested there. He had bail there, and he'd been denied bail in Northern Ireland. But moreover, in the proceedings in the Republic, there's been an order for discovery, which the recorder feels unable to make, or he's certainly postponed making until he sees the fate of the application for discovery in the Republic of Ireland. So there are both, there's first of all, it was the first executing state. Secondly, he's a citizen there and he enjoyed bail. Thirdly, he didn't abscond from there, so he was perfectly entitled to continue the extradition hearing there. And it was only because he was arrested in the north that anything intervened. And finally, there appear to be procedural advantages to him because there is an order for discovery made in the Republic of Ireland and in the proceedings in Northern Ireland. No similar order has yet been made. My Lord, we've
Sorry,
really...
Mr. Fitzgerald, the Republic withdraws its request. What's the consequential order in the Dublin High Court?
Well, no, I think what happened was that the Republic of Lithuania simply...
Well, that's what paragraph 48 tells us, but you told us that they had been discontinued against him in the Republic of Ireland.
That would be the effect of it, but it would simply be that, as I understand it, the prosecutor simply went in and said, given that they've withdrawn it, we discontinue it. There's no order. It just be
You also probably say it's an abuse of process to have all these various things when they have another go later.
Well, my Lord, it would be quite difficult when it's been his complaint that I ought to be proceeded with in the Republic. I mean, again, looking at substance rather than form, they'd say, hey, you've got what you wanted all along. You're back in the country of your citizenship.
Mr. Fitzgerald, one reason I think we may be here today is because I had a question mark against your paragraph 3F in your original document, one of many, the appellant's response to question 6. I'm not altogether sure I know what question 6 is.
Yes.
But I certainly want to know what, and I think you are repeating it in your present proceedings. The sentence, if he's discharged from the proceedings in Northern Ireland, he will not be able to return home, as he can easily be made the subject of a fresh warrant. Now, that I have difficulty in understanding. If it's a good point, it may be a good point, but if it isn't, well, then I don't know where we are.
Well, what's the point? The point is this. Each jurisdiction is free to commence extradition proceedings anew. So if he's discharged in Northern Ireland, he could go back to the Republic.
Yes.
And the Lithuanian government could simply say, we're dissatisfied with the judgment in Northern Ireland. We want to start again here. Now, of course, as my Lord Clerk has observed, it would be open to him to say, well, this is an abusive process, but they could say no.
It's an extraordinary idea, isn't it? I mean, having told them in the South that they don't wish to pursue it, having ceased the proceedings in the South, they continue in the North. The supposition is that he secures a discharge from the North. Is it seriously to suppose he can't go home?
Well, my Lord, that's
a submission.
Yes, that's a submission, but my Lord, it's section... my learned junior refers me to paragraph 17, subsection 5 of the judgment of Mr. Justice of District Judge, sorry, County Court Judge Burgess, or the recorder.
His Honour Judge Burgess, is he?
He's the recorder.
The recorder.
Yeah, the recorder.
Mr. Recorder Burgess.
But I think
paragraph what?
17, subparagraph 5.
This is your argument.
This is in tab 5. That's the judgment of His Honour Judge Burgess.
I know. Paragraph 16 is the submissions of the requested person.
Yes.
Mr. Fitzgerald.
This allows me also to...
Who's he argues? Fine.
Yes. Can I just take you to the paragraph 17?
Is the first word on the page, 5, this allows?
Exactly. Yeah.
What?
This allows me also to address the question of the
Paragraph
continuing...
17, subparagraph 5.
Paragraph 17, subparagraph 5. Yes, it is not uncommon for a requested person not to be surrendered by one country, but then to leave that country and find himself engaged in a process of surrender on the same warrant in another country, and for that country to surrender him. Such hearings take place on many occasions in England and Wales. And that is quite right, my Lord, that for example, you could have someone who, let's say someone fighting extradition to Russia in this country, who successfully defeats a claim for extradition in this country, goes to France and they start all over again. And he has to, there is no, as it were, automatic regime.
No, but there isn't usually the situation that we've got here, which is, as you point out, an unusual one.
No, it isn't. My lord, it is. But my lord, of course, he would have available to him an abuse of process argument. But it isn't automatic, because what is said is each jurisdiction is entitled to reach its own conclusion on these matters.
So I don't suppose he's conceding the point here and now.
My lord, no. I certainly don't want to concede that.
But just say, or any point of substance is possibly the bail point, and secondly the discovery point.
Yes.
So if they undertake to give discovery to Northern Ireland, that'll be the end of it.
Yes. My lord, it's not. It is unusual in the sense that it's unusual in this particular case is a rather exceptional case. But there are many people who, as it were, live both sides of the border. For example, as my own junior points out, there was a case of somebody being sought by Barbados, and I think his house was on the border, so he went to and fro, and he as it were, defeated the extradition in Barbados. But had he gone across, and the Republic then said, well, we'll start proceedings against you, without regard to the fact that there were already proceedings in Northern Ireland, there would have been the same situation reached. So we do say there is a problem. If you haven't absconded and you're engaged in prior proceedings in the original executing state, our submission of principle is that you ought to be entitled to complete those proceedings if you're not in breach of bail.
Am I right in thinking they made the request of Northern Ireland first?
It's not quite clear. That again is dealt with. I think they were sent probably simultaneously to both jurisdictions. In other words, the EAW is posted and then sent out to everywhere that it could be. So it's sent out to both of them. I don't think we have the dates, but it is referred to in the judgment.
The 18th
paragraph 13.
08 is what?
I think it's paragraph 13 that they say it was sent out. But in any event, my lords, there's no. It's not as if it was sent first to Northern Ireland, because he was based in the Republic. I think it was sent to both simultaneously. Well, my lords, you have the summary in 1.1 of the proceedings in the Republic. You have the summary of the proceedings in Northern Ireland on page 3 of the summary. We do just make this point at Roman 3 on page 3 that on the 27th of May 2009, the Recorder wrote to the Prosecuting General's Office as the requesting authority in Lithuania, explaining the background, the fact of the proceedings in the Republic, and stated, I personally see merit in returning him to the Republic. Then on the 28th of May, the Prosecutor General's Office responded to the judge, and they stated they saw no reason or point in returning him to the Republic of Ireland. Now, that was read out to us, or to my junior in open court, on the 29th. But in the same letter, they also complained about the slow course of proceedings in the Republic in the terms set out in paragraph 28 of Part 6 of the application. And they said, basically, it's taking far too long, and the speedy extradition proceedings have not been ensured by Ireland.
It does seem to have taken an astonishing time. And what about his Kirkus? Have they been extradited or discharged?
No, I think one of them, I'm afraid, has taken his life, and the other is still engaged in the proceeding. But actually, my lord,
I thought these proceedings were supposed to take about a matter of days.
Well, my lord, they never do. I mean, once.
But this is years.
No, but once human rights issues have been raised, Lithuania is a pretty controversial place to be sent to. There's been a case in this jurisdiction in England only months ago where a district judge refused to send someone accused of trafficking, someone who had been trafficked back to Lithuania on the basis that they couldn't protect her in the prisons. There's quite a lot of materials about the conditions in prisons in Lithuania.
I mean, that's the point for the substantive hearing.
Yes, and it's being determined.
So that could just as well be determined in Northern Ireland as in Southern Ireland, couldn't it? Subject to the discovery point.
Yes, my lord. I mean, we accept it. It's the same point. being determined. But
It doesn't really matter for the purposes of the warrant, does it? Where it is, as long as it's not in 5 places at once. And since now Southern Ireland has discontinued, what on earth's wrong with Northern Ireland doing?
Well, they've discontinued against him, but they can.
I know, so presumably they've had discovery, have they now, in Southern Ireland?
No, the order is being appealed, I understand.
Being appealed?
Yes, by the order of Mr. Justice Pierce.
So they may not get it anyway. But if they do, I mean, on the face of it, then the documents are there, available, no doubt, equally to you.
My Lord, I certainly that they would. But what we say is that it's right as a matter of principle that it should be determined in the prior jurisdiction, unless there's some new reason for it to be transferred, such as the person absconding and going to a different jurisdiction. And my Lord, that's the basis of the complaint. But your Lordships concede that our complaint is that there is an element of forum shopping here, that the Lithuanian prosecutor is saying, basically, they're not moving fast enough in the Republic, so I'd rather...
well, I don't see what's wrong with that.
No, what's wrong with that?
If your client chooses to go to a jurisdiction where it can be done more quickly, why shouldn't they take advantage of that? As long as they've discontinued the Southern Ireland. So what's wrong with that? That's a good thing too. No. So you've only got one process, namely in Northern Ireland. Nobody suggests that Northern Ireland's likely to be more adverse to your client than Southern Ireland.
Well,
or at least there's no evidence about that, and maybe an undertone.
Well, there's no logical reason it should be so.
No, well,
but you haven't been willing to strike there, have you? If that was your point, you'd have to spell it out in detail.
Oh, absolutely. No,
so we can assume that there's no difference between them.
Your Lordship can assume that it's subject to the point that in one jurisdiction there is no power to order disclosure, and that's because of the Tolman decision in the United Kingdom. And in the other jurisdiction, at least the High Court judge there considers he does have a power to order disclosure.
I see, there's no power in Northern.
No, well, that's right. In Northern Ireland, we're bound by the Tolman decision. And in the Tolman decision, it said that you can request, but you can't order a requesting state to give.
But you can presumably request, and if they don't respond to the request, it'd be a relevant factor in deciding what to do.
That's exactly the way that Lord Phillips put it in Tolman. That he said that it would be you could then, if the recorder asks for it and doesn't get it, he would have the power on the Tolman to say, well, this is an abusive process. You haven't provided information. But the starting point in the United Kingdom is always you have no right to disclosure.
So maybe as broad as it's long.
Well, my Lord, I prefer...
I mean, you might be better off without them.
I was going to say, maybe broader than it is.
Well, my Lord...
Because the material might be against you.
I think this is one which either offends the court's sense of justice or it doesn't. But what I'm respectfully submitting is that to have the Lithuanian prosecutor being told, you can choose, do you want him back in the Republic or do you want him here? And him to be able to say, this is long before they've discontinued in the Republic, oh, I think you do it faster than the other people, so you keep him and let the other defendants go on in the Republic. That, in our respectful submission, does offend against the sense of justice. I accept, of course, in both jurisdictions there are human rights protections and there are protections. But what our respectful submission is, it is forum shopping. And at the time that the matter was before both His Honour Judge Burgess and the High Court, we didn't have that letter saying, or that letter saying they're going too slowly. I want to stay in Northern Ireland because I want it to be dealt with in Northern Ireland. And we do say that then suggests him taking advantage of the situation to opportunistically put the prosecution in a better position. Whether he was right or not that it's going to be faster in Northern Ireland is another question. But that was the motive. But we also respectfully submit that there was a right to conclude the proceedings in respect of which he wasn't in breach of bail, he wasn't absconding, which had been entered into in the Republic. And your Lordship see that we deal with the satellite litigation point of Part 2. We respectfully submit that this is an objection which, if a correct objection, has to be taken as a preliminary point, because it concerns the initiation and continuation of proceedings in Northern Ireland. And of course, it was only after that point had been taken that, I think on the eve of the High Court hearing, there was the decision to withdraw the request in the Republic. I mean, in other words, they were well advanced along the course in Northern Ireland before they said, OK, well, now, in order to avoid the argument that you're trying to have it both ways, we will withdraw in the Republic. We say that it's not improper satellite proceedings. This is a threshold issue that has to be raised at the start. If your complaint is we're being tried in the wrong place, you have to take it before you have been tried in the wrong place. You can't say, well, we'll wait until the end of the proceedings. And indeed, it will be impossible to argue abuse at the end of the proceedings. And your lordships have our submissions on the merits of the application. That there's been interference in the proper course of proceedings in the Republic of Ireland by the Lithuanian authorities because they insisted the extradition hearing should take place in Northern Ireland. They were given an election and by the recorder, who was obviously saying, I see the merit in it going back to the Republic. And in their response, they elected to have the extradition proceedings determined in the alternative form of Northern Ireland simply because they were disenchanted with the time taken by the courts of the Republic. And at that stage, I think it was January to June, which actually isn't, when you've got human rights issues, a very long time at all. I mean, it's quite normal. And then we also say that it defends against the principles of comity. It suggests that, as it were, there is a better jurisdiction rather than treating all requested states alike. Your lordships then have our submissions as to why it's inappropriate to transfer. The original extradition proceedings were initiated in the Republic and were considerably advanced by the time of the initiation of fresh proceedings in Northern Ireland. The applicant, as the recorder himself found, had not absconded. He's a citizen of the Republic and resides there and has from the start enjoyed bail, whereas he's been denied bail in Northern Ireland. His co-defendants were being dealt with and continued to be dealt with in the Republic of Ireland. The allegations relate to an alleged importation into the Republic of Ireland of firearms and explosives, and Piet J has already made an order for discovery. It's questionable whether an equivalent order can be made, and that's because of the Tolman decision. And on all those grounds, we submit that the continuation of proceedings in Northern Ireland constitutes an abusive process. And we do make the point that there's no inhibition against the reinstitution of extradition proceedings in the Republic. It's a natural and proper forum, and we submit that it's undesirable that you have two neighbouring jurisdictions determining the same issues with the risk that they reach discordant results, and that if he succeeds in Northern Ireland, he goes back to the point I put originally to the Republic, and they start all over again. My Lord, those are the submissions, and it's on that basis that the only other point is that there is really nothing on this, which is all the courts recognise below, about what are the principles that apply in a situation like this. It's not dealt with in the framework decision, it's not dealt with in the Extradition Act, and it is the kind of situation that may recur, particularly in the case of the Republic of Ireland or Northern Ireland. Well, those are my
Thank you, Mr. Fitzgerald. Mr. Simpson.
My Lords, in the email exchange that my learned friend has talked about between the recorder and the Lithuanian authorities, it's right to say that the Lithuanian authorities, when they were first notified about this matter, were told that the requested person had been released on bail by the judge in the Republic of Ireland, a condition of which was that he was not allowed to leave the jurisdiction of the Republic without the court's consent. It appears, therefore, that the Lithuanian authorities were right to take the view that it seemed that he was in breach of bail, and that position remained the same right up until the decision was made by the Lithuanian authorities to withdraw the warrant in the Republic of Ireland. So it's not simply that they decided that it was going more slowly. On the face of it, he appeared to be in breach of his bail conditions and was in custody and in the course of a process in Northern Ireland. Once he was presented before the judge under Section 4.3, the arrest warrant, a process then had to begin in Northern Ireland. The recorder had no way of stopping it, only the Lithuanian authorities could stop it. They took the view, apparently, that he had breached his bail conditions, and they also indicated in their email correspondence that once the process has started in Northern Ireland, he may as well continue in the process in Northern Ireland. And it was in that context that they made the comment about the 60 to 90 days being the problem. And we respectfully say, therefore, there's no indication of forum shopping in the sense that my learned friend tends to suggest. In answer to my Lord Clark's question about discovery, the position is that the recorder in a recent hearing just before the end of our term, the last couple of days in June, was informed of the order of Mr. Justice Pearce Peart in the Republic and decided that he would write to the Lithuanian authorities to raise the issues that had been raised in front of Justice Peart in the Republic. That is an extant matter. He has not, as we understand it, had a reply from the Lithuanian authorities about the nature of the discovery which was suggested to the High Court in Dublin. So we're no wiser in that respect, my lords. We are not in a position to...
Who is your client? The Republic of Lithuania?
Yes. And they're being written to by the recorder. The contact is between the recorder and the judicial authorities in Lithuania, as it properly should be. And that's being done at the moment, so we're not in a position to know what Lithuania has said about that at this stage. My lord, we don't have the answer to that question yet.
I thought you were the Republic.
Yes, we are, but the proper contact is between the recorder and the judicial authorities. We do not have instructions in relation to that, Lords, but it's right to say that, as my friend has said, the judgment of Mr Justice Peart is under appeal, so one doesn't know what the position in the South is going to be. And my learned friend at the end of his submissions made the point that really all of when he was dealing with the Comity of Nations, my learned friend made the point that all of these, the convention states should be regarded as the same, and yet he seeks to gain an advantage by the fact that there apparently is a right to discovery in the Republic which has not yet been decided, and therefore he's saying that, well, because this jurisdiction does not grant discovery, and another jurisdiction grants, as it were, an extra layer of safeguard, then that's a better jurisdiction, and he should have that jurisdiction. In our respective submission, my lords, there's no basis for that at all. The appellant will, if he appears in front of the recorder, in a process which is continuing. In fact, we've already had a day's hearing of the substantive case, which has been adjourned. And that process is continuing, and these matters can all be addressed in the course of the substantive hearing about discovery, etc. They haven't arisen yet in the course of that, my lords. So we respectfully say that there is nothing in the abuse of process point at all. There is no bad faith being shown on the part of the Republic of Lithuania. It's clear from the Tolman case and the Simiu case that there has to be some bad faith on the part of the requesting state. For it to be an abusive process, and there's no evidence of that, we respectfully say. Lord, there had been no findings of fact by the recorder in the course of a substantive hearing in which these matters could be dealt with. There was a very limited number of facts before the divisional court from which this is an application for leave to appeal. And in our respective submission, there's no evidence of abusive process. Yes, it's right to say there doesn't appear to be a mechanism in either the framework decision or the Act for this type of position, but there is nothing wrong with what has transpired. There is a process. It's in a convention state. It's in a convention compliant state. And that process would be the same whether it be in the Republic of Ireland or in Northern Ireland, and it should be allowed to continue, we respectfully say. Otherwise, there's a difficulty that if this is struck out as an abusive process, there will be a genuine limbo, and the appellant could escape the rigours of justice altogether. In our respective submission, that would be an entirely improper matter.
On the bail conditions point, was there in fact a breach of the bail conditions, or only a perceived breach?
It appears that at the time that the email was written, and indeed at the time of the divisional court, there was uncertainty about it. It appears that there was not a breach of bail conditions when that was eventually looked into, my lords. But that wasn't known at the relevant time.
That's accepted now.
Yes, it did, my lords. Lords, unless there's anything further, I have nothing further.
Well, just briefly, for your lordships, have part 6, the appellant's response to question 6, which is, I hope, behind the application. If I can just take you to paragraph 28 there. It's on page 11 of the document. Yeah. Your lordships will see there that it's quite plain that the Lithuanian government, and we didn't have this available to us either before His Honour Judge Burgess or before the High Court, are saying the extradition proceedings have been in progress for half a year in the RA, e.g. the maximum period have been already exceeded. Thus, speedy extradition, we do not have any... It's quite clear that they're motivated by disenchantment with the length of time that the proceedings are taking. And we say that's an improper motive for saying, don't continue the proceedings as the recorder had regarded as appropriate in the Republic of Ireland, but continue them in Northern Ireland instead. And that is new evidence that became available to us on the 16th of August after the decision had been reached. And that's new evidence. As to bad faith, we say actually the concept of abusive process is somewhat wider than that. If there's something that undermines the due course of law, that's to say interferes with the proper course of proceedings, then irrespective of whether there's bad faith, that can constitute an abuse of process because it's oppressive and because it does interfere with the due process of law. But we do submit that that's an improper motive, if bad faith is required, to say we want things speeded up, so we'll opt for another jurisdiction. Clearly, when human rights issues are raised, very often it takes more than that period, and those matters are being addressed with equal deliberateness in Northern Ireland as in the Republic. So, my Lord, those are our submissions in response, and we do ask you to grant leave in those circumstances.
Thank you. We shall retire for a few minutes to consider. We're grateful to Council for their submissions in writing and orally. We shall dismiss the application for leave to appeal. We are satisfied that no point of law of general public importance, there is no such point which the court requires to consider, given that most of the relevant circumstances have already been considered by the court below, and in particular, this court is satisfied that there is no abuse of process.
That's